And the prosecution kept asking them, was it self defense? And I'm like, they can't ask them that. You know what I mean? Because these are regular people. Now, if you ask how many witnesses was it? 20? I don't recall. So I feel like even in that situation, we all are not perfect. How many times did Mike sit there and allow him to continually ask that question and never said anything?
I heard that question, but the correct question is, did he object when it happened, and did he preserve error for appeal? Because quite frankly, the prosecution asked crazy stuff all the dang time. But what you got to do, he was supposed to object, that question causes for the witness to make a legal conclusion. And what that means is what you were saying in layman's terms is this person isn't a lawyer. This person doesn't know, this person would need to know the legal definition, the black letter of the law definition to self defense to even answer that question. See what I'm saying? What people say in self defense is in a barbershop and a beauty salons, that don't suffice. You see what I'm saying? They need to know what's going on. So, and you could also object to them making an opinion on an ultimate issue. Now, me knowing what I know, they may be able to get away with a witness making an opinion on an ultimate issue. But I would still make the objection just to throw the prosecutor off. Okay.
Right.
But you object to that every time. And then if the judge act like he getting tired of you, you object to it again. And
Right.
then you ask for a running objection to that line of questioning. Okay. And not because you poking at the judge, but because you are blatantly putting in the jury's face. They not supposed to be asking them this. You see what I'm saying? And sometimes what I do, I'll say, Judge, this is misleading. They're not supposed to be asking it because the jury needs to know. You
Right.
know what I'm saying? The jury just needs to know. You got to find a way to the tricks and the trades of this thing to get these people to see it your way or the way that they ought to see it, not your way. But yeah, that's if that really happened, if that really happened, now what I do, I can relate to this because in a murder case, I think Mike, we asked every witness. The last question we asked him is, "You're not here to testify to what my client was thinking that day, are you? You're just here to show the jury these pictures that you took of the crime scene, isn't that right?" "Oh no, I'm not here to do that at all." No further questions. You can go X them off the list, jury. That witness didn't help you at all. You see what
Right.
I'm saying? So I can sympathize with what they're doing, but it's still improper, and it would definitely be an appealable issue. I would think, but not if they didn't object. If they didn't object, you waive your appeal.
Okay,
So
I'm glad you said that because that was one of the things that I learned by listening to all these other attorneys. One of the things they consistently stated that if your attorney does not object, you cannot appeal that particular issue. I know I'm saying it wrong, but essentially, if your attorney don't object to whatever they consider is incorrect, then you
mhm.
can't to the appeal court and say, I want to appeal on these specific things.
Right.
You said it right. Yeah.
The Sixth Amendment gives you the right to adequate and complete and a full defense and the right to counsel. And that counsel being adequate and providing effective assistance is knowing when to make the timely objections. I tell a jury when we pick a jury all the time, don't worry about objections. That's what we have to do as attorneys. As a competent attorney, I have to object. Whether the judge is ruling against me 100-0 or ruling in my favor 100-0. Y'all don't worry about that. That's our duty as a lawyer doing our job is to object, and it's the duty of the judge to make his ruling. But if we do not object, if we do not stand up and object, and you get judges that try to, and see, that's why you got to have a strong attorney because you get judges that try to little boy, they try to take
hmm
it down and shut up. And although that is so improper, especially when it's a white judge speaking to a black defense lawyer, but we'll get past that. But that is so improper to tell them to sit down when I have a duty to stand up and object for my client. But if you got a timid lawyer, who is more worried about his friendship with the judge after this, he's not gonna push that envelope like a mean
Right.
lawyer.
Right.
Because when we go in court, we're not worried about our friendships and our relationships with the DA. We only worried about our client. And
Right.
there's been plenty of times where we jeopardize our own freedom for the full defense of our client. Okay.
Right.
So you got judges that would try to discourage you from objecting, but you still have to stand up and object. And you know what?
Right.
he continuously to overrule your objection, just make a running objection. The Court of Appeals will still acknowledge a running objection. But
right,
again, tried and experienced lawyers know this. So if
right,
I don't know if Mike made that objection or not. I talked to Mike Howard, he responded to the email. He said he made the objections. I pray that he did because then Carmelo may have some action at appeal.
right.